Okay, excellent. Well, we'll go ahead and get started. Good afternoon, everyone. Um, Welcome to this webinar hosted by Branch Food and Wolf Greenfield, titled Protecting IP in Corporate Partnerships for Food Tech and Ag Tech Startups. My name is Sophie Friedman, and I'm the marketing lead for Branch Food, a launchpad for food innovation and one of the largest networks of food industry stakeholders worldwide. At Branch Food, we work to connect all corners of the food industry by way of educational and networking events that support innovators in bringing their products, technologies, and services to life, through our consulting practice for leading industry businesses that seek to achieve scalable growth, are looking for new revenue streams, and want to de-risk innovation. In our work, we've had great success involving our robust network of over 19,000 contacts and team of industry experts to see things others don't, which is what it takes to be competitive in today's global food industry. And lastly, we invest in businesses through Branch Venture Group, our angel investment network dedicated to funding early stage food businesses, including consumer brands, food tech, and ag tech companies. To date, we've led work with over 950 companies, big and small, invested over $4.5 million in early stage food related startups, and hosted over 250 events. We're honored to be doing this work and appreciate the opportunity to share more about it with you today. You can learn more about all of our work at branchfood.com and branchventuregroup.com, or reach out to me at sophie@branchfood.com. I'm also delighted to deliver the introductory remarks on behalf of our esteemed partners at Wolf Greenfield. Over the last 2 years, we've collaborated closely with Christina Licursi and Dr. Janice Vatland, who will be leading today's session. They are key members of Wolf Greenfield's trademark and copyright and biotechnology practices. Wolf Greenfield is a US-based intellectual property law firm solely focused on IP, with offices in Boston and New York. The firm has been at the forefront of IP strategy for nearly a century and is consistently ranked among the top firms in the country for patent prosecution, litigation, and post-grant proceedings. More than 90% of its attorneys hold science or engineering degrees with advanced technical backgrounds that uniquely qualify them to support innovation across food tech, biotech, ag tech, clean tech, and emerging related technologies. Christina and Janice bring deep insights and practical experience in representing early-stage startups navigating complex IP and trademark considerations in corporate partnerships. In today's session, they will use real-world examples that highlight how to structure licensing, manage trademark exposure, negotiate contracts, and conduct due diligence and safeguard new intellectual assets arising from collaborations. As a reminder, we will be recording this session and it will be available for you to view after the webinar. We will have about 15 minutes at the end of the presentation to take any questions from the audience. So please use the Q&A feature at the bottom of your screen to submit your questions. Also, we will be hosting office hours with Janice and Christina in September. If you'd like to sign up for a slot to get one-on-one guidance from these experienced attorneys, I'll include the link to register in the chat. I will also send it out in our follow-up communication after today's session. Without further ado, please join me in welcoming Janice and Christina to the call, and over to you both.
Thanks, Sophie. That was a lovely introduction, so I appreciate that. I'm Janice Vatland. I'm a shareholder in the biotechnology group at Wolf Greenfield, and I'm here with my wonderful colleague, Christina Licursi, a shareholder in the trademark group. Today we'll be giving an intellectual property primer, touching on IP considerations and best practices. And Christina and I, along with the members of our firm, Wolf Greenfield, and now I can't actually advance my slides. Hold on. You see that, right? Okay,
yes.
Wonderful. We have a lot of experience in a variety of intellectual property services. For example, we have experience with trademark clearance, selection and use strategies, brand education, and training, drafting and prosecution of registrations trademark registrations worldwide, drafting and prosecution of patent applications worldwide, patentability and freedom to operate assessments and opinions, portfolio audits, infringement opinions, maintenance of intellectual property rights, and as well as litigation and internet issues. So we have a varied experience, and some of these may impact some of the things that you are facing for your products and companies. So we're going to, as I said, give a little bit of a primer on what intellectual property is and why you should care about it, what you can actually protect, particularly with a focus on food tech and ag tech, and how can your IP be protected and what is key in securing that protection. So very generally, what is intellectual property? I know some of you may have already experience with thinking about IP, and some of you may not have thought about it at all, which is perfectly okay. So very generally, IP refers to any creations of the mind, anything that's within the realm of human creation, authorship, or inventorship. And intellectual property can be secured with particular types of IP rights that fall into four main categories: trademarks and copyrights, trade secrets, and even patents. And this latter category, I say even patents because sometimes you don't necessarily think about patent rights as being too relevant to your particular products and companies. But it is, and we'll get into that in a few moments. So one thing to keep in mind is when you secure your IP rights, these are exclusionary rights according to the law, which means that the owner of intellectual property rights has the right to exclude others from practicing or using that intellectual property. But it doesn't necessarily mean that you're able to practice your IP rights without perhaps securing other rights of others. So it's an exclusionary right, and the ownership does not necessarily give you the right to practice it. And this I'll touch on primarily within the patent section of the talk, and that will probably make it a bit more clear. So why should you care? So having intellectual property in and of itself doesn't prevent you from, marketing your product, providing you don't infringe others' rights. But having the rights to your own intellectual property is important to protect your sales and, of course, protect your monetization of your products. And it prevents competitors from simply practicing your intellectual property or copying your products. Intellectual property rights are also important to add assets and value that attracts investment. A lot of times inventors will want to invest in your company, invest in your products, but they will want to see that your intellectual property rights are secure and protected. And this is the way that you can do that by thinking about what are the different rights that you can seek legal protection. And intellectual property rights are also subject to licenses and development agreements. You can collect royalties and monetize your rights via these agreements. And in some instances, some of these license agreements include cross-licensing arrangements where you and another party enter into an agreement to commercialize each other's rights, and you might need rights from other parties and vice versa. So there's a lot of value in thinking about how to secure your intellectual property with the legal rights that are available. So the first one that's top of mind are trademarks, and my colleague is most expert in the trademark area, so I'm going to turn it over to Christina now to talk about trademarks and copyrights.
Yeah, so we'll start off with a little definition of what a trademark is. And sorry, I've had a little cough for the past week, so bear with my voice. It's back, so at least we have that going for us. So a trademark in its essence is really a source identifier. When we think of trademarks, most commonly we're thinking about those that appear on the top half of this slide. And so those are word marks, right? We have some examples there: Nestle, Whole Foods. In the food and fashion space in particular, names are also common trademarks. And if you think about the sort of origin story of trademarks, they were really used as like early stage stamps, seals, if you think of that, hallmarks, craftsmen, artisans, makers of food products would want people to know what it was that they were making and sort of put the proverbial stamp on the product. So that's why names are often associated with trademarks. Symbols are often common too, particularly in this day and age when we think of apps and the sort of visual interactions that we have with trademarks and those icons. And so those are something to think about protecting as well. Slogans. And then on the bottom half of the screen, we have what we consider more sort of non-traditional trademarks. And again, if what we're trying to get across here is a sense of when you see these things or hear these things, you know that there's a reference to a source or to a manufacturer. So the example of the sound, you hear the ice cream truck in the background, and you know that that's a Mr. Softy truck. Before you're watching a show, you hear the chimes and you know you're watching NBC, a lion roar, and you know it's an MGM movie. Colors are often used as trademarks as well. So the example here, we're trying to use a lot of food examples. You see the orange label and you know it's Veuve Clicquot. Similarly, you see a light blue jewelry box, and without anything else, you would know that that was coming from Tiffany. Shapes, and we'll do a deeper dive on shapes because shapes are interesting areas of protection in the food space in particular, but shapes can be trademarks. And then quirkily enough, I would say, scents can be trademarks, but a sort of underlying philosophy or ideology of trademark law is that there cannot be any tie between the functionality of the trademark and the product itself. So to give you a real example of that, I'll just go back on the scent example, because again, in the food space, this is particularly relevant. You could not get a trademark, for example, or a registration for the scent of a woman's fragrance because it's supposed to smell. The example that I have here is a tennis ball that smells like green grass. And why that's capable of obtaining a registration is because tennis balls should not smell like anything. In the food space, it's particularly challenging because oftentimes there are strong scents associated with foods. So oftentimes it's difficult to get registrations for scents in the food space. And now we can go to the next slide. And I love this slide in particular when I'm presenting with patent folks, because as you can imagine, there's so much interest in obtaining patent registrations around high-tech items. And of course, that's the case. But if you look at some of these examples, right, this is about company valuations. And of course, there are many high-tech companies, but here, what's always surprising to me is there are low-tech companies too. So we've got Coca-Cola, we've got McDonald's, we've got Louis Vuitton, and we've got Nike. And these are examples of the most highly valued brands in the world. The great example there is McDonald's, because I'm sorry, is Coca-Cola, because when you think of what Coca-Cola really is, there's no technology there, right? It is essentially a carbonated water with a flavored, some sort of caramel flavoring, and the company is worth literally hundreds of billions of dollars. And so these brands and the trademarks behind them can really matter in terms of company valuations. And we could go to the next slide. So trade dress, I mentioned this, and again, this is particularly relevant for a lot of food clients because it is an easy way to recognize the source of something. The best example here is always the Coca-Cola bottle, right? You see the shape of a bottle without anything else, you know that that cola is coming from Coca-Cola. You see the foil wrapping on a chocolate, and you know that's a Ferrero Rocher. So as you're thinking about what are protectable elements for various of your products, I just think that this is a really interesting layer as well. And we go to the next slide. So this is really interesting, and this comes up in food tech or low food tech, I would say, all of the time. And the best examples of where this is relevant is in the restaurant and food services space. But just something to think about. So unlike most of the rest of the world, trademark rights in the US are created based on first use of a trademark, not who files first. It's not a rush to the trademark office. Rather, you have rights in a trademark from the moment you start using your mark. And so what that means for you is the moment you start selling your bagels, or the moment you open a restaurant called Dawn Donuts in this example, you have trademark rights in Dawn Donuts, or you have trademark rights in Wolf Bagels. And registration is not required, but there are tremendous benefits to federal registration. And the biggest benefit is without a registration, you are limited in geographic scope to your rights. So if you only have your bagel store here in Massachusetts, presumably your rights are limited to Massachusetts. Where this gets really tricky, again, in sort of the food space, restaurant space, is you can think about it, right? Someone opens a bagel shop here in Boston and they have no goal to scale and to go outside of Boston, but they become wildly successful. And you open another store in Rhode Island, and wow, that takes off too. And you have not filed for a federal trademark registration. So now your rights are limited to Rhode Island and Massachusetts. And all of a sudden, someone's on the internet and they learn of Wolf Bagels in California. And you have no rights in California. And yet people are talking about Wolf Bagels, and perhaps you start shipping. So the situation can get pretty messy pretty quickly without a registration. And we can go to the next slide and we'll talk more about how this all sort of plays into a strategy too. Because as you can imagine, if you go back to my comments before, if you have trademark rights from the moment you start using your mark, a lot of early stage companies are concerned about costs naturally. And so one of the first questions we always get, or at least I always get, is why would I spend the money on filing a trademark? And the big advantage goes back to what we were just discussing. If you have a federal trademark registration, then the assumption is, the presumption legally is that you have rights in all 50 states, regardless if you have your bagel store in California, if you have your trademark registration, your federal trademark registration, your rights are valid across all 50 states. And critically, if there were real issues, right, and you've got your stores here in the Northeast and you find out about a newcomer in California and it's causing real problems for you, without a federal trademark registration, you cannot sue in federal court. So as things escalate and you become bigger, your renown becomes more, having an easy mechanism to enforce your rights becomes really important. The other nice aspect about trademark protection, and this is quite different from patent protection and different in spades, I would say, from copyright protection as well, is trademark rights can last for as long as you're using them. So occasionally we say forever, but we know that that's not the case. But it's perpetual. So as long as you're using your mark, 70 years later, 100 years later, you think of brands like Tootsie Roll or even Coca-Cola, those trademarks have been around for years and years. And so it's a nice sort of renewable right. And we can go to the next slide. So a lot of folks will ask, when do I need to start thinking about this? When should I file my registration, or file my application, I'm sorry. And the answer is, and I don't mean this to be trite, but it's as soon as possible, right? Because if what you're looking for is a path forward, and you're interested in developing your product, right? You don't want the distraction of something like trademark disputes to sort of take your time and energy and your money as well. So I would suggest that the earlier you can start thinking about buttoning up at least certain of your IP rights, the better off you're going to be in the long run. And especially in the sort of low tech space that I keep referring to, food products. Oftentimes the only IP right that you have is the trademark associated with it. And so to the extent that you can protect that, consider protecting that, the better off you'll be in the long run. And I know that part of this is supposed to be about licensing, and this is an important aspect to bring up here too, because without, it is possible to license a trademark without a registration. But I will say it is a far easier exercise when you're talking about dealing with any sort of corporate partners. It is far easier to say, you know, here is the asset that I have. Oh, look, here's the federal number that has been assigned to this asset. It just makes the conversations, the dialogue, the process so much easier. So if you're thinking about licensing in any sort of context, the other thing I would mention here too is investors like to see that you have, you know, your rights secured. And particularly if you're looking for investment dollars to scale, as many of you are, right? I think the local example is always a good one where you start off and, you know, maybe you're distributing at farmers markets and really sort of local. And then all of a sudden, you know, you have interest from Whole Foods. And it's not just Whole Foods here in Massachusetts, but it's more of a whole US play. And you need money to do that. So you start looking for outside investment. You'll have a far easier time assuring potential investors that you're serious about your product and serious about your company if you have your trademarks lined up. And we could go to the next slide. So just some considerations about, you know, when you're thinking about strong names and what it is that you should be, people will always ask, you know, like, what is a strong trademark? Is this something that I should protect? Is this something I could protect? And so we'll talk some about inherent strength of trademarks. But other things for you to consider are like, what does it communicate, right? You want your trademark to communicate something important about your product. And so if I think about, you know, even the visual depiction of a Nike swoosh, it's so elegant and so targeted, and you see it and you think fast, right? Because it's almost like there's smoke in the background, or it's turning into smoke. Another great example is like Puma for sneakers. There are such obvious strong connotations, and that's not by accident, right? But by using the name Puma for shoes, they're communicating something about their product. You want things that are easily remembered or pronounced. Janice probably knows this all too well, but in the biotech space in particular, right, we can think about so many examples of drug names where it's just like, it looks like this weird amalgamation of letters and it's so hard to pronounce. And so, you know, if we're thinking about quick experiences in grocery stores, we want something that's going to be remembered and easily pronounced. And we could go to the next slide. And this is just a nice sort of visual depiction of strength of trademarks. So on the one hand, we have generic marks. I shouldn't even say generic marks, I'm sorry, generic terms. And those cannot be protected as trademarks at all because there are dictionary definitions that are relevant to the product. And the theory there is that no one should be able to monopolize a specific term that is relevant to that product. And then everything else exists on a scale. And, of course we have buckets here, but this is intended to be a sort of sliding scale of strength here. So the best trademarks are those that are made up terms. The examples we have: Pepsi, Skittles, no dictionary definitions that are in the dictionary at all, for that matter, totally made up words. Those are the strongest trademarks, and I'll be honest, a lot of startup companies in particular don't really love those because they want something about their brand communicated through their trademark. So to take a made up term is often a little bit of a leap of faith that people don't really have the appetite for, at least in many early stage companies. So what we find are a lot of arbitrary marks being used: Trillium for beer, right? Trillium is a flour, Domino's for pizza, Five Guys for burgers. There are definitions, there are connotations perhaps that are associated with those terms that can be ascribed to those products, but it requires some sort of thought. And we could go to the next slides for just some more sort of examples there, because this really gets at the heart of what you should be thinking about as you are thinking about potential trademarks for your products. Again, fanciful are the best, but they come with some issues. Arbitrary marks, those are sort of, if clients or potential clients ask about, where do I even start? It's sort of, think about things that you like in the universe: constellation stars. I use the example of Trillium, right? Flowers, and how those might be able to apply to your products. That's always a good place to start. And we could go to the next slide. This just goes further on down the scale with some local companies too. And this is important. So when you're choosing a mark, you can do so much of this clearance work, at least on the trademark side, yourself, and you should. So first place to start is just easy internet searching, right? And if you think back to sort of where I started and where trademark rights begin, if they start based on one's use of a mark, if someone is using it, presumably they have a web presence these days. So those will help you knock out sort of obvious problems. And then the next thing is everything's publicly available that's filed with the trademark office. So you can do your own searching as a first pass, and we strongly suggest that you do in any context. And then once you have sort of a level of comfort, if you want more robust searching, that's where professionals like myself come in. But you can honestly do much of this on your own, and we encourage you to do that. You could go to the next slide. Just here, this goes back to sort of the scale that we were looking at a few minutes ago. Stay away from commonly used terms, right? Because they're just not protectable. And even if we could be cute and get a registration for something like drive safely and a slogan, because we do something highly stylized and know the workarounds with the trademark office, oftentimes there's no real value in doing that anyway, because you can't stop others from using things like drive safely or like go green. So think about really like what it is, if you are wildly successful, that you would want to spend your time and money making sure that others are not encroaching on. And then just a little practice tip is, once you come up with a name that you like, grab the domain name too, because they're assuming it's available, right? They can often be snagged up for so little money. And it depends so much on the term. If it is a term with a dictionary definition and it's just one word, then that's of course difficult. But if it is a combination of terms, then that becomes a much easier and less costly exercise. And we could go to the next slide. So common pitfalls, mistakes. obviously someone else is using your mark. So I can't underscore this enough. Do your homework, right? What you don't want to do is start off with a name associated with a product that you really like. I'll use my same example, right? You start off at a local farmer's market and it's Wolf's Bagels and you do no trademark clearance, and all of a sudden you're on a clip to really fast growth, and you find out that there are other wolves out there, and worse, you hear from the other wolf bagel that they're concerned with your use of wolf, and oh no, they're going to sue you. So just do your homework up front before you get too invested in and too wed to your mark. um, Other things, use your trademarks correctly. We see this all of the time on product packaging, right? There's TMs, there are R's with the circle. The R with the circle should be for registered marks. This gets a little bit technical, but use your trademarks as adjectives. They should modify something. So Nike brand sneakers, Veuve Clicquot brand champagne. They should not be used. They should not be used generically. Um, and we could go to the next slide. So life of a trademark, just quickly. Oftentimes we're asked this. What is the fastest I could get my trademark registration? Assuming there are no close marks. So again, assuming you do your homework, you file a trademark application, you're using the mark already, start to finish the process with the US Patent and Trademark Office from the time of filing to the time of registration right now is about 12 to 18 months. So keep that in mind as well as you're trying to scale. And I should also point out there are different ways to file a trademark application. So you can file based on use or you can file based on intent to use. And we can go to the next slide because this gets into the different bases. The intent to use is really sort of because trademark rights are based on use here in the US, the trademark office has a little carve out for these intent to use applications. And this is the vast majority of the applications that we file are intent to use. So before you launch your product, you do your clearance work and you file your trademark application because again, it's 12 to 18 months before you get your registration. The intent to use marks, they feel the same way when you file the application, but it is essentially a mechanism for you to be able to reserve your rights in a name before you are or in a trademark, sorry, before you start using that particular trademark. And the process looks the same, but at the end of it, rather than obtaining a registration, you get an allowance. And then from that allowance issuance date, you have 3 years to start using your trademark. In terms of dialogue with the trademark office, it's not always straightforward, and that's why professionals can be helpful in the prosecution process. That's the dialogue with the trademark office. So things that could happen when you file a trademark application, if you were to just make a really easy example, if you were to file your application for Wolf Bagels for food, you would get a rejection from the trademark office because that's not, food is not specific enough. They would want to know what kind of food. Other rejections that are possible are likelihood of confusion. So I filed for Wolf's Bagels, WOLF, and there is an existing registration for Wolf without the term bagels, WOLFE, for bagels and chips, or for potato chips. It's highly likely that we would get a rejection from the trademark office for that. Functional, I mentioned that before in the context of strength, of scent, but you cannot have functional elements associated with your trademark. And then descriptiveness, you cannot get a trademark registration for inherently descriptive terms. And we could go to the next slide. So I included copyright here because this comes up often. What is the difference between a trademark registration, copyright registration? Really, if we understand trademarks to be source identifiers, on the copyright side, the easiest way to describe it is its creative expression. Where is this relevant in this context is sometimes, right, we think of the Starbucks logo. Maybe it would not be possible for Starbucks to register that as a logo because maybe there was already a mermaid for coffee. If that were the case, what Starbucks could do, if it was really already wed to that logo, is file for copyright protection. It's more limited. So as the name copyright suggests, for infringement of copyrights, you really need a direct copy. Whereas on the trademark side, it offers a broader form of protection. It does not need to be a direct copy, rather it needs to be likely to cause confusion. And we could go to the next slide. This is just more on why one would want to copyright a logo or a design. And Janice, I think you're up for trade secrets.
Yes, yes. Trade secrets comes up quite a lot, particularly in the food space when you're dealing with recipes or some sort of method of manufacturing or producing a product. So trade secrets very much are used to protect the intellectual property around those items. So as I mentioned, recipes are usually kept secret, and the intellectual property is protected in that way, kept as a trade secret. For instance, recipe for Coca-Cola or the seasoning for Kentucky Fried Chicken, the flavors within Listerine, all of those recipes and formulations can be kept as trade secrets. And in addition to recipes, another big area that where some intellectual property is protected as a secret are methods of manufacturing, as I mentioned before. And this intellectual property right is a right to use or disclose. And it is basically any valuable proprietary information that can give you a competitive advantage. So it could be, as I mentioned, a recipe or manufacturing details, but it can also be business information, customer lists, anything that you find advantageous for your business. And that can be, that information, that intellectual property can be protected as a trade secret. Um, One thing to keep in mind is it has to be kept secret. So it has a value and it's something that you don't want everyone to know about, but it has to be kept secret and you have to have procedures to do so. And we'll go into more detail in a moment about what those may be. One thing that trade secrets are a little bit different from the other forms of intellectual property rights is that this is the one that's not registrable. So unlike trademarks and copyrights, and even patents that we'll talk about last, those are all secured by filing an application or a registration and getting a patent office to basically approve that application or registration. Trade secrets is not something that you actually file for. Instead, it has to meet certain requirements. It is one that you have information you have to own. It has to have value. And most importantly, you have to have that information subject to reasonable security measures. And these security measures are, of course, to keep it secret. They include physical security measures, confidentiality agreements and provisions, and these provisions are also used in options and licensing agreements. But to provide a little bit more color to that, in order to, one, keep your trade secrets actually secret, which is the desire, and then two, be able to seek damages should there be unwarranted or unlawful disclosure of a trade secret, you have to have the security measures in place. You have to establish a clear protocol or way of handling that secret information. For example, you probably don't want to share any secret information other than on a need-to-know basis. And when you do share it with another party, whether it's within or outside of your company, they should be under non-disclosure or confidentiality provisions in their agreements, whether it's an employment agreement or some sort of joint development agreement, et cetera. It's important to have this information only disclosed to those individuals that need to know it and that have to keep it in confidence. You also want to secure the information within your company in areas that cannot be accessed except by those who have a right to that information. For instance, you wouldn't keep information in a lobby where visitors can access it, or if it's electronic information, it's kept on locked, password-protected computers or in files that are password protected. So it's very important to keep things secret if you're going to seek to keep your intellectual property protected by trade secrets. And then also keep in mind that any time you should mark your information as confidential or as a trade secret, so that is clear, and so that the protocols are conformed to by those that are handling the information. And again, anytime that you're going to enter into an agreement where potentially trade secrets or confidential information should be disclosed with another party, you should make sure that those agreements have provisions that cover that information and spell out information if it's supposed to be a trade secret and have language that's appropriate for those situations. So a benefit for securing an intellectual property as a trade secret is that it doesn't have really a term. It could be indefinite or perpetual, as long as the information remains confidential. And as I mentioned, if someone violates a trade secret agreement or confidentiality agreement with you, unfortunately, that intellectual property is no longer protected because it is disclosed at that point, and your recourse is to seek damages through litigation. But the best practice is to avoid that situation and be able to keep your information confidential. A lot of information can be kept as trade secrets. So there is some information and compositions of matter or processes that you may also be subject to patenting. So there's a lot of times an interplay in terms of what do I decide to keep as a trade secret versus a patent. Because trade secrets have a lot of advantages, they cover more and the term can be indefinite. There is a strong preference at times to keep intellectual property rights as trade secrets. However, not everything can be kept secret, which then triggers you to think about, well, maybe I can potentially patent this information. So when you're considering what to keep as a trade secret or what to patent, it very much boils down to whether or not you think your information can remain confidential. And when that is not possible, that's when you consider patent protection, because a lot can be discovered by others, even if it's maintained secret. If somebody discovers the same thing, then that trade secret is no longer kept. It's no longer secret to you. A lot of things can be reverse engineered, and there are a lot of things that you'll have to disclose. So any of those sorts of information are things that are not available for keeping as a trade secret, and that's when you might consider patent protection. So I know that patent protection is not always top of mind in this space, but it does come up. There are a lot of compositions of matter and processes, and as well as product designs that can be available for protection by using patents. And I know that a lot of this seems high tech, but a lot of it can be low tech as well, and you can seek patent protection. For example, in my experience, There have been formulations for livestock feed that gives a benefit to that livestock that you might want to protect that formulation. And if there are certain components of it that you can't keep secret, you can try to secure patent protection for it. I mentioned product design. For example, if you have a product that you're making into a different shape, and you can possibly seek design patent protection for that. There's also more high-tech inventions that have occurred in the food tech and ad tech spaces. For instance, there have been genetically modified plants where the cells in the plants and the products that use them can be secured, protection can be secured as utility patents. Same thing with organisms. Some microorganisms, as some of you may know, may be used for biosynthetic processes in making different molecules, whether they're, for example, flavors or ingredients for different food products. So those recombinantly produced microbes, as well as the methods of using them, can be protected by patent protection. And things like, molecules, flavor molecules, or even sweeteners have been covered by patent protection. The molecules themselves, which are used in the food products, as well as methods of synthesizing them, also lend itself to patent protection. So these are just some examples. So as you're thinking about what you might want to protect for your products, don't discount patents and think about things that you might be able to protect with them. And that can't be protected by trade secrets. So a patent, just very briefly, is a legal document. You do have to apply for it, and after an amount of time and after examination, a patent office will give you the ultimate patent. And it allows you to, again, exclude those from making, using, selling, offering for sale, or importing what you have actually patented. And as I mentioned before, this is an exclusionary right. You cannot necessarily practice that invention that's been patented unless you are not infringing the rights of others. An easy example for this is, if you come along and find an important combination of sweeteners that give a good flavor without aftertaste in a product, that combination you can seek patent protection for, but because you get that patent protection doesn't mean you can necessarily make and use that combination sweetener, particularly if someone else has patented one or the other of the other components of your particular combination. Stevia is an example where someone may have invented it for putting it in food products, and you come along and combine it with something else, and that combination is what you're patenting. Doesn't necessarily mean that you can practice that combination if someone else had the rights to one of those components. I mentioned that there's utility patents and design patents. I'm not going to go into the nitty-gritty of all of that, but certainly if you want to know more about it, we're available to answer questions. And as I mentioned, patents are like the others, trademarks and copyrights, where you do have to seek and file an application and register it at a patent office. And there's requirements for doing that. They're different between whether it's a utility patent or a design patent, but generally they both have to be new and not obvious, and your application has to describe what you're patenting and teach how someone can make and use that. And unlike trade secrets, there is a finite term for patent protection, which is one of the drawbacks, although drawbacks at least over trade secrets, although there is a fair amount of term for patent protection, 20 years generally for utility patents and 15 years for design patents. There's also a process like with trademarks and filing a patent application at the patent office. This is just kind of a cartoon outline of where you can conceive of your invention. You file an application. There's different types of applications. There's what's called a provisional application for utility patents that are not examined right away, where there's benefits of using them. They are not available for design patents, however. So So keep that in mind. And then once you file a regular application for either utility or design applications, they're then examined at the patent offices where the examiners will review them for meeting the patentability requirements. And at some point, you'll achieve allowance, hopefully, and the patent office is ready to grant your intellectual property right as an actual patent. And then you pay fees and then maintain that right over time, also with paying fees. So this is just a general outline of that process. This is just a quick IP summary. I'm not going to go over all the details here, but just to keep in mind the four basic areas where you should be thinking about whether or not you can secure your intellectual property by these legal buckets of rights that we've talked about today: trademark, copyright, trade secrets, and patents. And this provides kind of just a quick cheat sheet for details about each of them. One thing that I wanted to kind of shift gears on, and this is key things to keep in mind for any of the IP rights that we're talking about today. It's very, very important to secure your ownership of those rights before you work with another party. The reason being is in the U.S. In particular, IP rights vest with the creator. So patents are owned by the inventors. Trade secrets are owned by the creators, which can be inventors or the commercializing entities. Trademarks are owned by the commercializing entity, and copyrights are owned by the author. So if you are working with employees or an independent contractor or some other party, you should make sure that if they're doing work for you to create intellectual property, that you have agreements in place before you start that work to secure the intellectual property rights for the things that they'll be working on. And we help a lot of clients in drafting such agreements and make sure that they include that necessary present assignment language in them, which is a bit technical for you guys, but that's our job to make sure it has the proper language in the agreements to transfer those rights from the creators to the entity that is ideally the one to own it. So it's something important to keep in mind. And then the second thing gets to this last bullet point, non-disclosure language. It's also very important to secure your IP rights before communicating with any third party and be the one to control disclosure. It's very important to file, if you can, and as appropriate, your registrations and applications before you disclose, sensitive information. You want to make sure those IP rights are secured before you start having those conversations. So this is applicable for all of the rights where you file applications or registrations, trademarks, copyrights, and patents. And then with patents, it's also important to make sure that you don't communicate and create bars to obtaining patent rights. In a couple slides before, one of the requirements for patent rights is that the information must be new and non-obvious. So if you make disclosures and create that information in the public domain, that can be used against you in securing your rights. So you want to make sure that not only do you want to be careful with third parties, you also want to not create bars to obtaining those rights. So it's very important to secure those IP rights before communicating with third parties. And then with trade secrets, again, yes, you very much have to think about whether or not you should make any disclosures. And of course, if you do need to make a disclosure, you want to make sure that it's protected by confidentiality and it's to only those that have a need to know of that information, and you have those reasonable security measures in place to secure that information. So two key things to always keep in mind as you proceed, regardless of what bucket that intellectual property falls in. These are two things to always keep in mind. Make sure you secure ownership and make sure you control disclosure and have your IP rights secured before disclosure. So it's about 5 till. We do have a case study, but Sophie or Aurora, if there are any questions, should we switch to that?
Great, thank you. I actually don't see any questions in the Q&A, so I think the case study would be great. And then when you're done with that, I'll just close us out.
Okay. Okay, great. All right, Christina, I'll turn you over to start us off on the case study with potato chips.
Yeah, so we put together this little hypo that we'll walk through, and I think it implicates all of the issues that we brought up today. So founder A starts a potato chip company called Sabao, and there are two other players in this. We're going to call them Executive B and Employee C. Sabao is incorporated in Massachusetts, and this is an important consideration for all IP rights. Janice touched on this, and I'm gonna put a fine point on it. Definitely set up a corporate entity. You do not want your IP held by you individually. It just opens you up to liability. It could be as simple as setting up an LLC that will at least initially own things, but we have Sabaus Incorporated in Massachusetts. So founder A starts this company. I think any founder knows that you become really passionate about your trademarks, the name of the product, the design elements. So he wants a logo that looks like an angry meerkat. And he knows that employee C has amazing drawing skills. So what is founder A going to do? Founder A is going to ask employee C to create a logo for these potato chips. Founder A has something that he thinks no one else has, right? He has a secret seasoning that he thinks is delicious for his potato chips. And in addition to that, he has a way of preparing these potato chips that make them a little bit crunchier and a little bit different from other things that are on the market. That's why he hired Executive B, right? He wants Executive B's expertise in this food development, manufacturing process of these chips. And Sabao is really taking off in Massachusetts. So we'll go to the next slide that sets the stage. So at least on the trademark side, just some considerations as we're looking to scale, as I would frame this company from something small to something hopefully much bigger. So Sabao, great trademark off the bat, fanciful. So we should do some clearance work on Sabao. There are other things that we should be considering too. Should the tagline is crispy snacks. Would we want anything like that? Probably not. Going back to my comments before, even if you could get a registration for it, what good would that do? Owner of Sabao or company Sabao, because there are plenty other companies that are referring to all sorts of snacks as being crispy. Potato chips, that's the product, not something to protect. Roots, maybe that becomes something, right? Maybe there is some sort of organic spin to this, and roots is a cool play on that. So that's one that we would likely table. And then the design of the meerkat is something that we'd be interested in too. And then we'll just add some more layers to this. So trade secret protection. Janice, you want to jump in here?
Oh, sure. So if Executive B must know the recipe, so that's the combination of ingredients and the amounts of all those ingredients, prior to sharing that information, Founder A, of course, should have Executive B sign an employment agreement with non-disclosure provisions. It's also reasonable to have that agreement have a non-compete clause in that as well to protect that information even more. And because we're talking about trade secrets here, again, it's very important that this information stays secret, especially a recipe, and it should not be shared with anybody else. So that those non-disclosure clauses within the agreement with Executive B would have provisions provisions where he must keep that secret and not share it with anyone else, and they should make sure that that doesn't happen. And the recipe should be secured. As I mentioned before, there should be reasonable security measures to protect where that recipe is located and make sure that it's marked confidential and not everyone has access to it. And I should say, even within companies, not everyone within the company, even if they have signed an agreement with confidentiality, should have access to such a highly important trade secret. It's really at most one, two, no more than a handful of folks that might know the actual recipe, even if other people. It very much should be a need to know basis for something like that. And then with respect to patent protection, if your seasoning or whatever was created by the original company owner is a new flavor molecule or something new to include in food products, and that information can't stay secret, that's when you might want to consider filing for patent protection. And again, that application should be considered and filed, if appropriate, before any disclosures are made, ideally. And then Founder A should still seek the same protections that we talked about before with respect to Executive B signing the appropriate agreements with the appropriate provisions. And still, the recipe should not share just because you seek patent protection. That's for things that are must be disclosed or would be disclosed and be in the public domain. The recipe itself still can be kept as a trade secret, even if you seek protection for a component of that, this new flavor molecule or a particular ingredient in a food product. And the recipe, again, should be marked confidential and kept under reasonable security measures. So this, Christina, was a picture putting it all together. I'll put in the background that the recipe kept as a trade secret and potentially in green, considering patent application filings.
This is the beauty of generative AI. So we have the product package here. We've got our angry little meerkat. The one piece we didn't talk about was the copyright, the design of the meerkat. Even if you are working with your employee, unless it is a full-time employee, if it's a part-time employee, work for hire employee, you would want some sort of agreement with said employee to make it clear that any sort of design that he or she creates is owned by the company and not by them individually. But this is, yes, Sabao should be marked appropriately with the trademark. In this case, we have it registered. We have the design element as well. As Janet said, recipe kept as trade secret, potential patent application, and then it's always nice to include a copyright notice as well. But that is essentially all that we have. I see
Thank you, Christina and Janice. I'm just going to hop in quickly. I know we're a little bit over time, but Mark had a question in the Q&A, which I can just read. He says, how do you protect your IP if you're currently a bootstrapped startup, but already working with large multinational customers, and the amount being paid for our services isn't enough to cover the cost of any IP-related protections? Would you like to jump in on that?
Yeah, we can try to. I'm curious to know, right, if any of what we said resonates. I'm gonna guess that if you have layers of IP that you think are protectable, there's probably some that could be potentially in this line between patent and trade secret. And Janice, I don't know if you want to talk about how to sort of walk that line for someone who has such strong sort of cost considerations too.
Yeah, I mean, certainly cost is always a consideration. Presumably if you have something of value, it's still worth the at least a little bit of amount of money to seek, some high level guidance from someone with respect to your particular, whatever your particular situation is. Some of intellectual properties, particularly patent protection, can be quite costly, but we very much work with clients to try to balance helping them protect their intellectual property and cost. So even our most cost sensitive clients that are at early stage in the startup space and that have minimal resources, there still is the opportunity to get counseling with respect to what would be available for protection and how to go about it. And certainly, some of the things that we touched on today with, trade secrets, putting those things in place to make sure that those things are not disclosed, and even for patents, making sure you're securing those rights and then disclosing them or not disclosing them as appropriate are worth considering. But I would, recommend, be able to really provide more detail to answer this question, at least a high level conversation, a hypothetical conversation, which a lot of us are happy to do without incurring a lot of costs. And I will mention and put a plug in for our office hours in September. So that might be another way to get some more details and then a more maybe specifics for your particular situation.
Excellent. Thank you so much. I just put the office hours link in the chat again. So, Mark, maybe that's a good way to get a follow-up on your question. So, just take a look at those and sign up if you can. Um, so I'm just gonna close us out and say thank you again to Janice and Christina and the whole team at Wolf Greenfield for your collaboration around this fantastic webinar. Once again, if anyone would like to connect with Wolf Greenfield or the Branch Food team, we would welcome your outreach. You can reach me at sophie@branchfood.com and just share how we can best support your respective efforts. And an email will be sent out in the next few days or perhaps next week with a recording of this webinar. So thank you so much, everyone, and have a great rest of your day.
Thank you.
Thanks, everybody.